We're going to try to have a lively conversation as we wrap up what has been a very, very interesting day. What our plan was to, there's us. And what our plan was today was to each of us to pick a topic that was particularly relevant and interesting and topical in our jurisdiction and sort of go a little bit deep into that topic. And then the rest of us were going to sort of weigh in and give you some thoughts about sort of how that topic was playing out in other jurisdictions around the world. Given that it's gotten late, we're not going to do that part. So I think that our goal for you today is just to give you a taste of what we saw as some of the hot topics in a couple jurisdictions around the world. So that's what we're going to do. We hope to wrap this up with some interesting thoughts. We're not going to rush, but we're also going to try to do this in an efficient and relaxed and thoughtful way. And so Geraint is going to kick things off and talk about enforcement authority. I'm going to just send this down to you.
Thank you. Thank you, Jeff. Lovely to be here. Hopefully you can hear me properly. The UK update then, what is new? The main thing, and I talked about this last time we all got together, but for those of you who weren't there and to bring everybody up to speed, the main thing is in the UK, consumer law is undergoing something of a revolution, which will impact advertisers and agencies and everybody else involved in the ecosystem, and slightly broader as well. So claims on packaging and claims on everywhere you want to make claims, essentially, this impacts. So in a nutshell, what's happening is that the current law, which is in the European-style consumer protection from unfair trading regulations based on European law, is being replaced with the DMCC, Digital Markets, Competition and Consumers Act. And what that means is that we're slightly departing, but the general trend in Europe seems to be towards enforcers being able to issue very, very large financial penalties based on a percentage of turnover, and that's exactly what we're doing in the UK. I'll come on to the amounts, etc. in a minute, and just to flag that misleading claims are top of this list. So the regulators are going to be looking at misleading claims across all different sectors and all types of misleading claims, but with a particular focus to start with on pricing and discount claims, green claims, a common theme across the day, and a couple of other related areas, fake or misleading reviews. So if any of you or your clients host...
Yeah, and I think he wants you to be closer to the mic.
Sorry. Any of you host misleading reviews at all, on reviews that you aren't sure whether they're misleading or not, you now have new obligations to make sure that those claims are not misleading and that they are genuine. And subscriptions. Next year, we're going to have new rules on subscriptions, when you have to notify people, etc., of the updates and how much it's going to cost them, and all of these sorts of things. There are three regulators that are of interest. The ASA continues to be the main regulator for advertising in the UK. So we'll continue to see the ASA do what it's been doing for a very long time, business as usual there. The other two, though, are the CMA, Competition and Markets Authority, and Trading Standards. Trading Standards is the kind of regulator that people engage with from time to time. They haven't got very good resources. They're very stretched. You can have a conversation with them. They say, we think there's a problem. You say, oh, that's terrible. Tell us all about it. And then you have a conversation and eventually they go away. The CMA is a different body altogether. They will not engage in that kind of conversation with you. If they knock on the door, it's because they want to investigate particular claims that you're making, and they're not going away. They have huge resources, and they have the stronger powers under these new rules. What are those stronger powers? So the stronger powers are that the CMA is able to directly enforce consumer laws. So instead of having to go to a court and convince the court that you've breached rules and misleading consumers, now the CMA will decide whether you've breached the rules. So they'll target who they want to, they'll decide who to investigate, they'll conduct the investigation, and they have strong powers to compel disclosure of information. They will issue their ruling at the end of it, and spoiler alert, they'll think that you've breached the rules, otherwise they wouldn't have bothered to get that far. And they will issue the ruling and then issue sanctions and decide on the level of sanctions. And the level of sanctions can be up to 10% of annual global turnover. So if you're dealing with global clients and global businesses, these are very, very massive amounts. They're probably not going to, let's face it, issue the maximum penalties in the variety of different sort of ranges of misleading claims that we deal with day to day. You'd have to go some to irritate them enough to get the 10% sanction. But the ability for them to issue that level of fine is there. They also have a sort of sliding scale that they can use, and that's all been published, and we can provide you with information if you want on how they calculate the levels of the fees. They also have the ability, though, if you ignore them, if you're not disclosing information that you should, or if you've given them written assurances and then you breach them, they have the ability to issue daily financial penalties as well of between 1% and 5% of your daily turnover. And again, that's on a sort of global basis. So that is the big news, is the CMA. Previously, we didn't really have to think about them. Now they are at the forefront of this kind of regulation. And it's become a sort of C-suite issue. With these levels of fines, it dwarfs the GDPR fines that we've been talking about. So it really is a sensible approach for it to be treated very differently now, consumer-facing claims, than it has been in recent years. Trading Standards is also able to enforce these rules, by the way, and to seek 10% type penalties, but they have to go through the courts. So they are not given the power to issue the financial penalties themselves, and so their powers are not as strong as the CMA. So that's why we talk about the CMA, in addition to the fact that the CMA has been resourced up, ready to go. And so the ASA's powers, as I say, are completely unchanged. They are likely to be the day-to-day regulator. I think the lookout here is when there are areas that the CMA has expressed an interest in, whether it's green claims or other sorts of targeted areas, discount claims, pricing claims, that's when the ASA might step aside a little bit and allow the CMA to come in. So when you're dealing with those sorts of issues that the CMA has already said are in its crosshairs, that's when we're interested more in the CMA. So yes, when we're looking at these types of claims, we are dealing with a different risk assessment than we were before these rules came into effect. And the date, by the way, that these rules come into effect is this coming Sunday. So it will happen not tomorrow, but the following Sunday, the 6th of April. So no, this coming Sunday. This coming Sunday. So it's happening soon. So from Monday, we're expecting quite a few requests from clients saying, why didn't anybody tell us about this? And we've been trying to tell clients about it for about 2 years now, but we are still getting those last minute requests. But we're very, very happy to help with any of those sorts of queries, because there is a sense of urgency around this for anybody who hasn't been paying attention in the UK. That's the main headline, I think, for the UK.
All right. So I think, Jasmina, I think you're next.
Hi.
You need to turn on your mic there.
Thank you. So, hi, everybody. I would like that we talk and discuss, well, we'll not really have a lot of time to discuss, but at least food for thought about whether certain campaigns are actually corporate social responsibility, or they're actually just a way to health wash your brand. So it's not that, it's not that a lot of things are happening in Bosnia and Herzegovina. So I'll just give you a couple of notes on how the legal landscape looks in Bosnia and Herzegovina. So generally, it is very much deregulated, especially in terms of digital advertising. In terms of TV and radio, there is some regulation, but in essence, everything can go online. So I would like that we discuss or think about two campaigns that were running in Bosnia and Herzegovina. So first one is Unsmoke Your World, and the other one is Be Brave, Be Healthy. So the first one, Unsmoke Your World, it's a campaign. So it is a campaign by Philip Morris. So it's my understanding that it ran globally, but in Bosnia there is one specificity that I didn't see happening in other countries. So what they wanted to do is to paint a mural on a building in city center of Sarajevo, which would have a kind of effect to clean the air. The issue at hand was that they signed an agreement with the City Council of Sarajevo and also municipality of Old Town, where the mural was supposed to be painted. Given that we don't have any regulation regarding those kind of advertisements or campaigns or any kind of campaigns that raise awareness, obviously this could just go unless there were actually what happened in practice, that people actually opposed this campaign going as a mural on a building. Why? Because they didn't find it to be genuine. It is not genuine according to activists in Bosnia and Herzegovina, because obviously what they think is that painting a mural on a building with effect to clean the air is a question whether it can actually clean the air. And then in the other hand, whether a brand that is producer of a tobacco is a brand who should be paying or raising awareness of this kind of campaigns. So this is a question among the health activists. And also they said that because according to WHO regulations, you can't really work with tobacco companies, or any kind of regulations to that sort would be seen as covert advertising. The activists opposed this campaign, and in the end, it wasn't found genuine and it wasn't implemented. And then the other campaign, it's similar to some extent. It's called Be Brave, Be Healthy. So this campaign was run by Ožijsko Pivo, or Čuja, that's its nickname. And the main message of this campaign is to raise awareness of the prostate cancer and to advertise or raise awareness that you should, as a male, go and check regularly whether you have a prostate cancer. So, okay, yeah, sorry. The main points here about this kind of campaign is whether an alcohol brand should be doing these kind of campaigns, given that alcohol is also a risk factor to cancer. So I've researched while I was preparing for this presentation to see whether alcohol is a risk factor for prostate cancer, and apparently it's not a risk factor for prostate cancer, but it is a risk factor for colon cancer. And, you know, the proximity of those two organs, that's very close. So I guess if you think about it, you have to think whether this is a genuine message or this is a covert advertising. Another problem about this campaign, as I saw it, is it's a Croatian brand, and so Bosnia and Herzegovina is a bordering country to Croatia, and one of the things that it was advertised there is that you could go and get a free test, but only if you were in Croatia. So from the Bosnian perspective, as a Bosnian citizen, it means that you really couldn't get the free checkup because you're not based in Croatia. So I guess we all have to think about it, whether it is an ethical thing to have a campaign that would raise awareness about testing for a certain cancer, while at the same time, maybe it could cause another cancer. Given that we, as I said at the beginning, don't really have any regulatory authority, this campaign in the end was implemented. So I would like for you to look at this video, and given that we don't have time to discuss it, well, you can think about it afterwards, how do you feel after watching this campaign?
Dođe vrijeme da se krene, svako muško mora znat. I tvoj rođo, i tvoj pajdo, susjed, otac, sin il brat. Žena, djeca, kuća, posao, mogu bez tebe taj dan. Misli barem jednom na se, budi hrabar, odlučan. Ajmo, braćo, u sam glas, kucnuo je i taj čas. Nek se tresu ulice, jači smo od sudbine. Neću plakat, neću pustit suzu, ani suzicu. Preživjeli smo 100 put gore, valjda ćemo i taj prst.
Za momka čvrsta nema straha od prsta. Prijavi se za besplatno testiranje. Budi hrabar, budi zdrav, jer žuja je zakon.
So obviously žuja is Ožujsko, and yeah, it was implemented. So that's the main point. Yeah, you also had it in Serbia. So, thank you.
Thanks, Jasmina. That's great. We don't have time to show you the other slide that she had prepared that showed you the exact locations of the colon and the prostate. We thought we were, but you can get those separately. Okay, so Jenny's up next.
Hi, everyone. It's great to be here. I wanted to touch on something that really ties into two different types of aspects of our practices. And the one is the link between trying to enforce traditional trademark and IP rights against passing off an unlawful competition, and then looking at the regulation of advertising and how those tie in. So just to give you a little bit of background, in South Africa, advertising is regulated either at a self-regulatory level or at a statutory level. On the self-regulatory front, we have the Advertising Regulatory Board, which is the ARB, and they're exactly like the ASA in the UK. They have a code of advertising practice, and all members of the ARB are obliged to follow that code. There have been problems with their jurisdiction over the years, and their jurisdiction has been successfully challenged against non-members. So what you sometimes find is if you want to file a complaint against somebody who's not a member of the ARB will still consider the complaint, but the ruling against that party may have implementation problems. I'll explain a little bit more about that later. Then we have different markets in South Africa, or industries that also have their own self-regulatory bodies. There's the CTFA, which is the Cosmetics, Toiletry and Fragrance Association. They have their own code of advertising practice, and that particular code has also been implemented in the ARB code. So there's a tie-in between the two of them. Aware.org is a self-regulated body that deals with the advertising, packaging, and promotion of alcoholic beverages in South Africa. It's not outlawed yet, but there's a lot of talk, along with what Laura mentioned with the certain unhealthy foods. There's a lot of effort being made by the government to try and clamp down on the promotion of those products. So the Aware.org's code of advertising practice is also incorporated into the ARB code, so there's a tie in there too. I didn't want to deal with legislation because that's a topic for another day. It's much more interesting to talk about self-regulation. So what we have been finding in South Africa is that a lot of competitors are trying to ride off the reputation and the goodwill that exists in a market leader product. And what we find is that there are two different instances. The first instance is where you've got a newcomer coming into the market, and that newcomer will automatically go and look at what is the biggest competitor in that market doing with their packaging. Or you've got somebody who's been in the market for a number of years. Their packaging is looking a little bit tired or a little bit boring. So they try and make changes over a period of time to move closer and closer to the market leader packaging. So this was the subject of an ARB complaint. These two products, competitors, direct competitors in the trade. I need to explain to you what Mageo is. It's a maize fermented drink, and it's very healthy. It's also extremely popular in South Africa, and there are a number of companies that manufacture the product, but the market leader is RCL Foods, and they are the product at the top of the page. They are called Number One Mageo. And they make a smooth drink, which comes in a variety of flavors. Just going to say the flavors are often indicated by the color of the packaging. And you'll see in a while why something like that is important. The product that is in the line below that is a competitor called Barclay Foods. They've also been in the market for a number of years. But what we found was that over time, they continued to change and change and change their packaging. So if you look, now we've shot. So if you look at the top line, you can see how Barclay Foods changed the line of their packaging to come closer and closer and closer to RCL Foods. And at the beginning of this year, RCL Foods filed a competitor complaint against Barclay Foods, and they used two very important sections in the ARB code. The one deals with imitation. And remember, under our ARB code, the definition of advertising includes packaging. So they used imitation. They said, you've imitated our packaging. And to be successful for a claim against imitation, you don't have to prove that there's any confusion in the trade. So you don't have to prove that somebody, a consumer, will be confused between the two respective products, the market leader and then the advertiser. The other section in the code that they used is Section 9 of the code, which deals with exploitation of advertising goodwill. And exploitation of advertising goodwill is a completely different creature because it deals with what you've done with the reputation and the goodwill. Because if you think about it, to create the reason why you've moved from where you were to where you are now, if you're the advertiser and you're changing your packaging, is precisely for that reason, because you want to ride off the back of somebody else's reputation and goodwill. And interestingly, in this case, there were two issues that were highlighted. So Barclay Foods was not a member of the ARB code, so they filed a response, but they said that RCL Foods should rather have sued them for passing off an unlawful competition, and then set out the reasons why RCL Foods would not have been successful if they had sued them for passing off an unlawful competition. And the ARB said, we will make a decision based on the complaint anyway, because people who, for example, might manufacture your packaging or other advertisers that place your advertising who are members of the code would want to know about the fact if a ruling has been made against you. That was the one important aspect of the case. The other important aspect was that there was a discussion around, in relation to a certain product that appears in the trade, there are certain market trends and market standards. So in South Africa, for example, manufacturers of pre-sliced bread products, blue generally indicates, oh, that's embarrassing. That's my phone ringing. Sorry about that. Sorry, that's the office. I don't have to wait. So in South Africa, if manufacturers of pre-sliced manufactured bread that comes in like a square brick where all the slices are in the bag, blue generally indicates white bread. I mean, blue, not as in the bread, but the color of the packaging. Red indicates brown bread. Green often is like an industry standard color that's used for like whole wheat or other types of bread. So this was the main argument that Barclay Foods raised. They said, well, first of all, nothing turns on the shape of the packaging itself because these are industry standards. And second of all, the colors are the colors are the colors. They indicate the flavors. You can't claim that because you have a pink bottle or a pink box in relation to a strawberry flavored product that gives you any greater rights than anyone else. But when the ARB considered the complaint, they focused on something that we often refer to as pack architecture. They said if you break the product down into its different components and its different elements, and you look at where certain elements on the packaging are placed, you can see that there's been an intention, number one, to imitate, because even though the brand names are completely different and the products might have slightly different color elements, and even if those color elements are standard in the trade, you can see that there's been an intention to copy. And ultimately then found against Barclay Foods and ordered them to change their packaging. So what is not responding? So what the clients will often come and ask us is, well, what do we do about this? Are we going to go to the ARB and file a complaint, particularly against an advertiser that's not necessarily a member of the code, or are we going to sue them traditionally in the High Court? And really, the options turn on a variety of factors. Of course, going to the High Court and trying to enforce your rights is a very costly exercise. It takes very long. At the moment, our courts are backlogged. It's very hard to get a date. If you go to the ARB and you file a complaint, they generally will deal with the complaint in just over a month and you'll get a ruling. So why would you not do that? It's also much cheaper and much more efficient. And it's also a factor of, in terms of expertise. So if you consider that the two of them, and they're not mutually exclusive, it's not that you have to do the one or the other. It's just which is the best option for your particular client in any particular circumstances. And I've just set out in this slide exactly what the differences are and why it's important to make the right decision. The biggest issue with the ARB, of course, as I mentioned, is the enforceability. But the best thing, even if enforceability is a problem, is that you get a lot of advertising out of it. So there's a lot of press attention. The press loves writing about the ARB decisions. So you get a lot of negative press for the advertiser if you were successful in your particular complaint. What we have also found in our courts is that a lot of our judges struggle with the concepts of intellectual property law and intellectual property law enforcement. We don't have dedicated IP enforcement courts or tribunals. So it's a bigger risk on Geraint's scale of low, medium, and high. You're between medium and high if you're going to court, and you're on the lower end of medium and the higher end of low. Does that sort of make sense if you rather go to the ARB? So that was really just what I wanted to highlight for you, is just these are some of the trends that we're seeing at the moment. There've been a number of decisions from the ARB that deal with packaging copying. So I hope you found that interesting. Thanks.
Thanks, Jenny. Okay. I think, am I next or is Lisa next? I can't remember.
Before you.
Are you next, Lisa?
Yeah.
There you go. All right.
All right. So one of the hot topics in Norway is whether AI-generated advertising could be labeled as arguably misleading. Surprise, surprise, the Norwegian Marketing Act prohibits misleading and untruthful marketing. Here we go. So this is from a campaign from a bank run in Norway last year. It's featuring a guy named Harald. He's 29 years old. And according to the ad, Harald earns money without lifting a finger. And of course, the purpose of the ad is to get consumers to save money in the bank and earning interest. It's a pretty innocent ad. Somebody figured out that this was an AI-generated image, and it hadn't been disclosed. And it created a huge uproar in Norway. Politicians said, well, this should be illegal. And of course, the bank said, sorry, next time we'll use a real person. The consumer authorities didn't do anything, so nothing really happened. Let's see here. Here we go. I'm sure you've seen a lot of kind of examples of AI gone wrong. This was an example, I think it was gathered by the New York Times. It shows the same AI image by a guy for advertising for different products, different services in different countries, different languages. I mean, the guy is everywhere. He's kind of like the George Clooney of AI, but so it can go wrong. So over to Norway again. We have a specific rule that's unique to Norway when it comes to labeling of images. I'm not talking about AI images, just general images. It's a new regulation that came into effect in July 2022, and it requires labeling all retouched images. So if you have an ad campaign targeting a Norwegian audience, you have to have a label on the image if the image has been reworked, meaning retouched or have some kind of form of manipulation of the body, shape, size, or skin. And this is being kind of coming into effect because they want to get away from the body pressure, especially for young kids and younger generations. And as you can see from the photo here, it has to be marked, and it has to be about 7% of the advertising space. So it's quite a large mark, and it has to be in the upper left corner. So it's very specific. Yeah, that would have been fine. You have to have some kind of retouching, or it has to be digital. And so it's been very it's hotly debated because it's kind of where do you draw the line in a way. I'm just going to show you how the label looks like. Here we go. It can be downloaded from the Norwegian Consumer Authority website as well. So something to be aware of if you have advertising in Norway. Now, how is this related to AI? So since we have this specific regulation, the question was then, well, can we use this regulation to also say that if an image is AI generated, then we need to have some type of labeling. We can use the existing regulation to kind of expand to AI. And this came ahead in the spring. Let's see. Here we go. In 2023, when SATS, it's one of the largest fitness centers in Norway, they placed an advertising billboard in front of the Norwegian Parliament, showing an ad that was created by AI and said this should really be banned. And the politicians again said, yeah, it should really be banned, but do we have the law to do that? And the Norwegian consumer authorities, they used about 6 months to look into the issue, and they figured out, well, we can't really extend the current rules to also apply to AI-generated images. So we're back to the Norwegian Marketing Act and the general rules. We don't have any regulations per now, although the minister has said that, well, something is going to come for the next few months, but we don't know yet. So just briefly, at the end, I'm sure you've all seen this and you're kind of already tired of the EU AI Act. But we are getting proposed rules on labeling of AI in the EU. The law is only coming into effect or entering into force in, I think, August 2026. And Article 50, which I'm sure many of you are aware from before, has a two-tiered system. One is saying for AI created images, there needs to be some type of labeling, maybe a watermark, they're not really sure yet. And then for deepfakes, it needs to be clearly marked. I'm not going to do a deep dive into the long Article 50, but that's something to be aware of, and it's coming pretty soon. The act hasn't been implemented in Norway yet, so it's probably going to take effect later. And we usually use this one from the FTC in the US for kind of giving tips to clients in Norway. I think that's a good kind of clear rules on how to deal with AI in advertising.
Cool.
Thank you.
All right. Thanks, Lisa. I think it's me to wrap things up.
Yeah.
Thanks, Jenny. So, there's a million things to talk about, and I thought that I would talk about sort of a couple of environmental advertising issues as a lens to look at the way in which we're struggling about how we're thinking about advertising law right now in the US. And I think what's really, really interesting that's going on is that I think if you went back 20 years and you took an ad and you said, if I brought this to court, if I brought this to the National Advertising Division, which is our self-regulatory system in the US, if you brought it to a regulator, you'd have a fair degree of consensus about the way in which people would come out. We were pretty aligned about what does it mean to be a consumer? How does a consumer interpret advertising? What types of ads are misleading? And I think that we're not there right now. And I think that we're not there right now for a lot of complicated reasons that I could probably talk about until it's dark. But what I want to do instead was just through that particular lens of looking at the ways in which we are sort of rethinking the way we're thinking about advertising law and what do ads communicate, and the ways in which we're seeing differences between courts and regulators and self-regulation approaching these issues. It's just a really interesting moment right now in terms of counseling in the US. And I think that it's interesting as I've seen other jurisdictions also struggling with some of these issues with sort of either a lack of alignment or evolving advertising standards or changing conceptions of what it means to be a reasonable consumer. So what I thought I would talk to you first about is about aspirational claims. I think, if you went back 10 years and you said, what does the self-regulatory system think about aspirational claims? Meaning, our goal is to be carbon neutral by 2040, or, we're going to achieve these particular goals by this time. The self-regulatory system had pretty clear standards that were pretty well accepted in the U.S., which is that if you make an aspirational claim, you should have a reasonable plan in place that's going to help you get there, and you should be already being proactive and taking steps in order to get there, and you shouldn't really be doing other things that suggest that the kinds of things that you're doing are. Of course, I'm not moving my slides at all, and There we go. Okay. And you shouldn't be doing something that would suggest that the kinds of statements that you're making really just aren't achievable. And it was a pretty well accepted standard that we were following. So here's a case that an NGO brought against Coca-Cola, basically suing Coke, arguing that Coke's aspirational claims are misleading. And you can see here that they're making promises about, when their products are going to be made of 100% recycled content and how much of it's going to be recyclable, and giving specific dates about it. And what was interesting is that the trial court in the case dismissed the lawsuit. And they dismissed the lawsuit saying, these are just aspirational claims, right? These are just your statements about what you hope to achieve in the future. And we just don't believe that consumers are going to rely on those when making a purchasing decision. We don't believe that consumers are going to think that you've actually got proof that you know that you're going to be able to achieve those goals by those dates. And so when that case first came out, I was like, wow, that's amazing, right? We're looking at a court who's saying, hey, we're really rethinking sort of a basic standard that people had accepted about, what this meant. The appellate court in District of Columbia actually dismissed the case and said, no, we don't agree. We do think that aspirational claims are claims. We do think that they require substantiation. And in fact, there were a bunch of really interesting things that came up in that case. Oh, yeah, if you don't mind switching your slide too, so I can follow. That's awesome. Thanks, Jenny. So the first thing is the court thought about it through the lens of who the advertiser was, right? And they looked at Coke and they said, you are a giant user of single-use plastic products. In other words, you're a bad guy and you're like a cigarette manufacturer. And I think that one of the things that we're seeing right now as the ways in which courts and regulators and others start to think about how you judge someone's advertising and what their standards are is we're kind of classifying them as good guys or bad guys, or are you a problem or are you not a problem? And we're looking at the lens not necessarily through this lens of, how is the advertising going to be interpreted, but also who you are and how you fit into the marketplace. But the important thing about this case is that lower court said, no, we don't think aspirational claims are claims. The appellate court reversed and said, no, we do think that they're claims. But the court still struggled with the issue. The court still said, well, we do think that certain types of aspirational claims are claims, but we don't know what the limits of those are. Like, we imagine that there are certain types of aspirational claims that may not really rise to the level of the types of claims that consumers would want substantiation for. So this seemed like, okay, so there was a little bit of a back and forth here. Courts weren't really sure where to go with it, but appellate court sort of stepped in and said, typical claims, probably claims, but there are probably some limits. Okay, so here's another case. This is now a case that the New York Attorney General brought against JBS Foods. JBS is maybe the largest producer of meat in the United States, like beef and pork and poultry and things like that. And so JBS made similar claims. They promised that they were going to be net zero by 2040 or whatever it was. And the New York Attorney General sued, and the New York Attorney General sued basically saying there's no way that those are reasonable claims you could be making because you just don't have any basis for them whatsoever. And the first thing that the New York Attorney General said was, you're claiming that you're going to be net zero by, I think it was 2040, even though you've never calculated your scope 3 emissions. So you don't even know what the total emissions are that you're trying to, actually, zero out on. So there's no possible way you could have a plan in place to get there. But even with that, the New York Attorney General argued, look, the kinds of things you're doing as a producer of meat is that you're expanding your meat production. You're doing more and more and more. You're doing all of the things that are causing more of the kinds of greenhouse gas problems, where at the same time, there's no technology out there that would allow you to be net zero in this way. And so, the New York Attorney General took this very aggressive position that, look, there just simply was not a basis for these claims. And even though they're far out, even though the 2040 is far away, and even though JBS is saying, look, we don't know how we're going to get there, but we're going to get there, they really felt that the claim itself was not substantiated and was false and misleading. So interestingly, court dismissed the case. Lower court in New York dismissed the case. Again, saying basically, these are aspirational claims. We just don't see it. We don't see that consumers are going to take these kinds of claims seriously. We don't think that they're going to rely on them. And we don't think that they require the type of proof that you're arguing that they make. So in terms of the aspirational claim piece of this, where we are right now is we don't really know where we are right now, right? We've got courts going back and forth. We've got regulators going back and forth. We've got self-regulation, everyone coming out on this in different ways. And we really don't know, what the law is in the U.S. right now about these types of forward-looking claims. All right, so let me give you one more example before we wrap things up. There have been in the U.S. many lawsuits brought against fossil fuel companies across the United States. Various state attorneys general, other regulators have been bringing lawsuits against them. And I mean, to reduce the lawsuits to the most general, abstract, unhelpful statement, right? At the end of the day, in terms of the false advertising claims, the regulators are arguing that you should not be promoting the sort of incremental improvements the incremental good things that you're doing, because you're causing such enormous harm that the little drop in the ocean that you're improving is completely insignificant in the context of all the harm that you're causing. In other words, the idea that you've created this one little motor oil that now has improved your performance by this like half of a percentage point, really to promote that and to suggest to people that you're doing good things in the world is highly misleading because of all the harm you're causing. So there are all these fossil fuel cases that are out there. They're across the country. They're all ongoing. And, there's a big question of, well, what does it really mean? In other words, are these just about fossil fuel companies? Remember the lawsuit in the Earth Island case against Coke, where the court compared Coke to a cigarette manufacturer, right? This is very much about like the tobacco cases that happened in the U.S. 20 years ago, which is, we're looking at these people as bad guys. We're saying you've done this thing. What is the lens in which we're going to think about this problem? Interestingly, the Supreme Court and the U.S. Supreme Court had the opportunity to consider whether these cases, they should put a stop to the cases, and the Supreme Court allowed them to continue. So for now, these cases are continuing. But the real question that they raised for me when I saw these cases happening are these cases just about fossil fuel companies in the way that the tobacco cases were just about tobacco companies? Or do these cases raise a larger question of how do you promote the good things you're doing if you also do a lot of bad things too? And were these cases going to lead to other kinds of cases which raise this kind of fundamental question about how do you talk about the incremental improvements that you're making? And of course, in fact, there have been these cases. So let me just give you two quick examples. The first is a case that the Los Angeles County in California brought against Coke, another case against Coke. And basically what LA County argued was that Coke was engaging in false advertising because they were promoting all of their sort of recyclability and sustainability efforts, and that they were misleading because, you're promoting all of these incremental improvements that you're making, but at the end of the day, the harm caused by all the single-use plastics that you're using, either because of lack of recycling and because of microplastics, really was never going to, all the improvements that you're promoting were never going to certainly outweigh all the harm that you're causing, but it was really misleading to consumers because consumers were thinking that, hey, single-use plastics are a viable option. It's actually a good thing. You can feel good about it, when in fact it's really causing tremendous harm. So the kinds of arguments that LA County was making was things like this, like don't promote that your Dasani water bottle is made of 100% plastic because consumers are going to understand this to communicate that all of Coke's products are made of 100% plastic. Now, there's nothing in this ad that suggests that, but the argument is that by promoting one of your products as being an improvement is going to imply to consumers that others are as well. Another example is that it's misleading to promote the idea that a product is made of recycled plastic without disclosing the harms that plastics can cause. In other words, that you have an obligation, if you're promoting a product that can cause environmental harm, that you have an obligation to have some sort of warning, to put the product into context, to explain the harm that it's causing. There should be one more example here. Yeah. Oh, okay. So these cases, this case in LA County is ongoing, but it's raising this exact same issue that these fossil fuel cases are raising, which is you've got this product causing widespread environmental harm, right? We don't have the systems in place to manage it in the way that's going to solve these problems. So is it misleading for Coke to promote the good things that it's doing if it's never really going to solve the larger problem? Or how do you do it? Is there a way to talk about the incremental improvements that you're making, understanding that big picture, there's still this harm going to be caused? So this case is ongoing, but at the same time, New York brought a case against Pepsi, basically making very, very similar allegations. This is, again, the New York Attorney General suing Pepsi, basically saying you shouldn't promote your recyclability efforts, you shouldn't promote your recycled plastic, because at the end of the day, right, the harm of microplastics, the harm of plastic in the environment, is so huge, and whatever you're doing is really never gonna get anywhere. And the court dismisses the case. The court says, nope, we don't buy it. We don't think there's anything misleading about making truthful claims about what you're doing, and we don't think that you have any duty to warn at all, right? So we're at this crazy moment right now where these cases are being brought, and the courts and the regulators and self-regulation are swinging in all of these different ways, and we don't know what any of the answers to any of these questions are. And when you think about the climate crisis that we're in right now, let alone lots of other crises that we're in right now, you can see that we have absolutely no idea where any of this is going to come out right now at a time when it's a really important issue. So that is some thoughts I'm having about that. Thank you all for sticking with us to the end of the day. Hande, maybe you're going to tell us about what's next, but thanks all of you, and thanks for listening.